Teach and Share Week 7, Chapter 13, Bankruptcy, taught to my mom on June 1st. So, do you understand what bankruptcy is?
Yep. It's when you go before the court and you explain why you can't pay your bills. Yeah. But there's different kinds of bankruptcy.
There is. So bankruptcy can occur in the legal standard dealing with business law. There is bankruptcy law. So business can occur when a business entity or an individual is unable to pay their debts. And bankruptcy law provides ways to resolve those debts. So those type of fixes, those remedies, are provided to individuals, partnerships, LLCs, or corporations. So bankruptcy laws are set up to balance the claims of the creditors with the inability of the debtors. So that basically means that, the debtor is the person that's not able to pay the money, whatever pay off the debt is. Creditor is the individual or business which is looking for the money. So assets are the value of the property owed should exceed the liabilities, which is what is owed. Does that make sense? Okay. So when liabilities, so what is owed, exceeds the assets, the property owned, insolvency, or what is known as the inability to pay debt, can lead to default. So if you can't pay your loans, can't pay this, can't pay that, become a debtor. So bankruptcy laws have two goals. It ensures that creditors competing for the debtor's assets are treated fairly, and also allows the debtor to be able to have a fresh start without the inability to pay that preceded the bankruptcy, which makes sense, but at the same time is kind of interesting that it's kind of like a fresh start, but not really a fresh start, because there are other things that
it's a fresh start within 3 to 7 years, depending on what form of bankruptcy you file.
And it's different when it's businesses, it's a little bit different. So, do you know how bankruptcy laws came to be?
I do not.
So it used to be that debtors would go into debtor's prison.
Yeah.
And that's where they would do laborious work to work off the debt and the incarceration fees that occurred. So when the ratification of the U.S. Constitution occurred in 1789, Congress was given the ability to create bankruptcy laws to alleviate some of the stress that is on the debtors, which I didn't know about. I just was like, oh, bankruptcy laws, okay. Didn't know how they started, why they started.
I didn't know that either.
So bankruptcy laws, like a lot of things, are governed by both state and federal law, which means the proceedings can be different in each state. But, as always, bankruptcy can't be filed in bad faith. And it's illegal to lie, hold assets, or falsify reports when filing.
Yeah.
So you kind of mentioned kind of almost the process of bankruptcy proceedings. So most cases will follow the standard. You file a petition, which will almost always be voluntary, which means that the individual or business entity files on behalf of themselves. There are a small amount of cases, about 1%, where cases are filed by a creditor if certain conditions are met. So once it's approved, a stay is granted for creditors' actions against the debtor. Do you know what a stay is?
Yeah, it means that they can't go after them.
Nope. It puts a hold on everything. They can't enforce. They can't
get money.
Nothing.
Can't do anything.
Yeah, and I was like, oh, like I said, I knew basics of bankruptcy, but didn't understand all of it. So it's nice to know that there's going to be a stay that you can't do anything. So after that, the court will determine whether or not the bankruptcy is, if the case is approved or not. Then there's a creditors meeting. So creditors must meet with a reasonable amount of time, and the debtor can be called in for the meeting to do any witnessing, stuff like that. A trustee is appointed and will be the mediator of the meeting in an attempt to distribute any assets that is found appropriate by the creditors. So again, it's that mediator in the middle for working between both sides. As well, creditors must show they have a right to payment, which is called a claim. And those have to be submitted within 6 months of the meeting. And if the claim is not valid, then it can be disputed by the trustee. So there's, if something's disputed, they can say, hey, no, wait. So a payment plan must be set up and approved by the court and creditors which will be implemented later, that payment plan. So they have to set up, this is how it's going to pay the bills, how we pay off the debt. And then debts usually will be discharged. So that, you know what that means?
Yeah, it means they don't have to pay.
Yeah. So priority of claims. So this will determine the fact of who gets paid first. So bankruptcy codes establishes priority among the creditors and is valid because it will determine, like I said, which creditors get paid and in which do not, because not all creditors are going to get paid.
Yeah.
There's always at least one that won't. So secured creditors will get their security interest first, and then priority claims can get paid. So priority claims are domestic support obligations, which are for like child support, money to spouse, stuff like that. Administrative expenses are for like the trustees, any attorney fees, stuff like that. And then employee wages are if the creditor owes money to employees, the courts will allow employees their wages up to about $11,000 for each worker. So there can be some money that they get from the debtor to pay. So there are exemptions for the debtors, which I didn't think there would be. I didn't know that that was a possibility. So the Bankruptcy Code is set up for debtors to come out of the process with something to live on. If not, the entire purpose of the law wouldn't work. You have to be able to have somewhat of a leg to stand on after everything. Some limited assets are allowed to be kept, which are referred to as exceptions. And the law is not uniform. Again, this can differ between each state. One state could say you can keep this cow or whatever. The other state can say, no, you can't keep your cow. It all depends on the state. So to prevent what is called state shopping by debtors to find, what state will allow them to keep the most, it is a requirement that they have to live in that state 2 years before you file the bankruptcy.
Just 2 years? I thought it was 5.
This is the most recent information, and also laws can always change, so it can be more or less depending on what occurs. So additionally, federal law allows debtors to keep a personal property up to $575 per item, which includes furnishings, clothing, animals, crops, and books, but is limited to a total amount of $12,250. So you can keep some, but there's a limit to how much. So after the bankruptcy or post-bankruptcy, once discharge has been received, the debtor is not legally required to pay any remaining debts, any remaining dischargeable amounts that came before the bankruptcy filing. And of course, just because you file for bankruptcy doesn't mean that life is super easy, super smile, super happy. There are going to be debts that can't be discharged. You know what kind of debts won't be discharged?
I do not.
So some of those are debts that were not listed in the filing, student loans except in extreme cases, taxes, alimony and child support, and debts that are incurred by fraud or embezzlement, which that kind of is like an almost, yeah, that would make sense. You can't keep, fraudulent or embezzled money. So there are 3 different types of bankruptcy. They're all called Chapter 7, Chapter 11, Chapter 13, and they're all based on what chapter they fall in the Bankruptcy Code. So the first one, Chapter 7, is liquidation proceedings, and usually is the most common type of bankruptcy. So it is known as liquidation and allows the bankruptcy trustee to make an accounting of all the available assets in order to pay off the creditors in the order of priority. Once assets are spent, the rest of the debt is discharged. Individuals or businesses, entities can file this type of bankruptcy. And in 2005, Congress passed the Bankruptcy Abuse Prevention and Consumer Protection Act,
I remember when that happened.
which is an effort to stop abusive behavior. Part of that is set for people to pass the means test, which means the debtor has to make less than the state's median income for them to file for this type of bankruptcy. If they make more than the median, they have to file for Chapter 13 bankruptcy. So once it's approved, the trustee will collect the assets of the estate and then will distribute them to the creditors. The only ones that won't be sold are the exempt assets. Once the estate is distributed, the remaining debts again will be discharged. If fraud was committed, the discharge is revoked. So you can't, again, you have to follow the rules and laws. You can't commit fraud, you know. And if a business filed, there is no discharge, but the business is dissolved after assets are liquidated. Debt that remains can't be collected because, again, the business no longer exists. You have to be a functioning business for the debts to be collected. So the next type of bankruptcy type is Chapter 11, which is reorganization. So this is a process for businesses to fix themselves and continue to operate from the debt that can't be paid. Yeah. And most of the time, businesses will retain possession and be able to control the business through the bankruptcy. The creditors committee is formed to represent the interests of those who have claims against the business. And a reorganization plan has to be set up and has to be presented by the business. Well, that plan has to designate classes of claims and ownership interests, specify which classes or interests are impaired, what would be negatively affected by the plan, specify treatment of any claims or interests that is impaired by the plan, provide the same treatment for each class, and provide adequate means to carry out the plan. So you have to give a plan as to, this is how I'm going to work out to get out.
Yeah.
So it means that the plan must outline how it's going to be fairly dealt out. Not all creditors will be paid, so the plan has to be fair and that the company can come out of the bankruptcy with a chance of surviving. And once approved, the court grants petition and the remaining debts are discharged. And the last one, Chapter 13, is the adjustment of debts.
That's when you get to pay them back.
So
it's my personal favorite. I think it's the most honest of all of them.
So it's also known as the leftovers. No one really wants this, but it does happen. So if a person doesn't qualify for Chapter 7, they end up filing for Chapter 13. This serves to prolong the time the debtor has to make payments on the debt for a discharge before the discharge can happen. Mm-hmm. Debtors must make payments on their debts within 3 to 5 years before a discharge happens. Only individuals can file for Chapter 13. Businesses can't. Yep. Which I didn't know. I thought businesses would be able to do all sorts, and I'm like, oh, they can't. So, again, making connections, you know, to every class. I mean, this will interact with my international business because I have to know if I'm dealing with a business that filed for bankruptcy, I have to know what my rights and abilities are to collect the debt. Or if I am in a business that files for bankruptcy, I need to know what my rights are and stuff. So again, everything is tying into each other. International business class is tying into international politics, which is tying into business law, which I like that it's all connecting together, even though it's not all same subject at the same time kind of thing. But I had a small understanding of what bankruptcies were, but this has really expanded my view. So I'm kind of grateful I was able to learn about it this week. So what did you learn some?
I did. Yeah, I did. I mean, I knew some of it. I have a client that's was a bankruptcy attorney before he retired. So I remember when 2005 happened.
Yeah.
Because it was a huge pain for him.
I bet
it changed things a lot. He was not terribly happy with it.
Yeah, I mean, I understand why they would have that set up, but then I also understand what kind of problems that could cause for an attorney.
I think it was the most major bankruptcy law change he told me in his career. So
that's crazy.
He's been doing it for a long time. But yeah.
Well, thank you. I'm glad that I was able to teach it. It was a lot of fun to discuss. So thank you.
You're welcome.